Good afternoon. This is John Lande from the Dickinson Law Firm here in Des Moines. Thank you for sharing your lunch hour with us. We're going to be talking about cash management agreements as well as some electronic funds transfer issues that are kind of top of mind right now. I'm going to start things off here this afternoon. Again, my name is John Lande. I'm chair of our law firm's cybersecurity practice group, as well as a member of our banking group. And so my focus is going to be on cash management agreements and what they can do for your financial institution. And what I'm thinking about here and what I'm going to be talking about are agreements that govern the relationship between your institution and your deposit account holders who engage in some kind of electronic funds transfer, whether that's ACH transactions or wire transfers. And of that group that may engage in any of those EFT services at your institution, this presentation will be focused on those of your customers who are non-consumer accounts. And so this focus of this presentation is on your non-Reg E governed deposit account holders. So these would be entities like businesses. They'd be individuals who are maybe conducting business through a sole proprietorship or some other entity, as well as organizations like churches, charities, schools, anyone who has an account for something other than primarily consumer purposes. So Regulation E applies to those accounts that are primarily for consumer purposes. Everything else is governed by a separate law called the UCC, the Uniform Commercial Code. And so that's my focus here today, is on liability rules for your institution under the UCC and how you can use your cash management agreements to protect your financial institution from potential liability from an unauthorized wire transfer or ACH transaction. And to kick things off, I want to start with an example that is really a cautionary tale, or it should be for every financial institution. It involves an unauthorized wire transfer that occurred involving a wealth management company. And this particular wealth management company handled the assets of high net worth individuals. Organizations like these crop up in areas with a high density of high net worth people. Basically, these high net worth people don't want to spend time managing their day-to-day finances, so they contract with an organization like PSG to handle their day-to-day lives. And so as a consequence, these individuals give the companies like PSG an extraordinary amount of access to their personal financial information, including the power of attorney, as well as access to bank accounts, and allow these individuals to handle the finances on their own. So PSG had access to the bank accounts of high net worth people. And on one particular day at 9:10 a.m., the controller at PSG received an email that was a phishing email from a fraudster. The email purported to be on behalf of a lawyer who claimed that he had been in touch with one of the directors of the company. For all intents and purposes, it was the president of the company, and that the president of the company had authorized a substantial wire transfer that needed to go out of PSG's account that it held at a financial institution. At 10:15, so about an hour later, that controller who had received that phishing email received a call from somebody who purported to be that lawyer. And that lawyer claimed that the director had authorized a fairly substantial wire transfer that needed to go out of the PSG's bank account that day. At that point, the lawyer emailed wire instructions to the controller, and the controller then turned around and forwarded that email to the bank. Now, I've worked with a lot of financial institutions where that might have been the end of the story, where the financial institution would have gone and just followed those instructions that had been emailed to it. For reasons we'll talk about in a few minutes, it's very fortunate for the bank that they did not respond to that email. Instead, the bank called back the controller and said, no, we can't initiate an EFT like this. You have to get in and use our online system, which has a number of security features that are designed to prevent somebody other than an authorized user from initiating that EFT. So sure enough, the controller did that, logged into the bank system, and initiated the wire transfer. The bank's fraud detection system, however, flagged the transaction and said that this is unusual activity for that account. And as a consequence, it triggered a callback review where somebody from the bank actually called that controller back and said, we're not sure you really want to do this. Can you please verify that you actually want to send out $1.7 million? The controller then confirmed that the quote-unquote lawyer had actual authority to authorize that transfer. And, of course, the lawyer, who was really a fraudster, said yes. And so at that point, the bank released the money because at the end of the day, it's not the bank's money, it's the customer's money. So ultimately, that case turned into a situation where PSG sued its insurance company because PSG thought it had coverage for that particular kind of cyber attack involving a phishing email. So that's something the insurance company disputed, and that litigation is ongoing. This case very easily could have turned into a situation where PSG was suing its financial institution. And the reason that the financial institution was able to escape liability in this case is because of the procedures that the institution used to verify the authenticity of that wire transfer that PSG was trying to send out. Now, I don't know for sure because this wasn't an issue in the case, and I don't have any way to access this information. But I strongly believe that the agreement between PSG and its financial institution made quite clear what the elements of the security procedure were that the bank was going to use every time PSG wanted to initiate a wire transfer. And my hunch is that because that agreement contained the elements of that security procedure, PSG, when it was looking around for somebody to blame for this unauthorized transfer, looked at its agreement and decided that it was simply not worth the effort to try to sue its financial institution for this fraud loss. Now, a number of you or a number of institutions might look at this and say, well, of course the bank shouldn't be held responsible because under these circumstances, the bank, told the customer that maybe this is fraudulent. They flagged it a couple of times. And they had conversations with the customer. So the customer should be on notice that the wire transfer was unauthorized or potentially fraudulent. And so it shouldn't matter what our agreement says between our customer. And I'm here to tell you that regardless of what the actual facts were, a deposit account holder who loses money out of an account because of a fraud will always look to the financial institution to try to recover because they bring with them into their business lives that experience they have as consumers, which is that under Reg E, if their debit card gets stolen and somebody makes a charge that isn't authorized, the bank always reimburses them. Well, most people have difficulty differentiating between that aspect of their lives and their lives as business owners. And so it becomes critical that your agreement with your deposit account holder, if it's a business or other non-consumer organization, spell out what the bank's going to do to verify electronic funds transfers before they go out. Because if the bank does that, it can avoid liability entirely for those unauthorized transfers. So if we look back at PSG and we ask ourselves what could have happened, well, the lawyer could have sent an email with wire instructions. The controller forwarded that email to the bank, and then the bank wired funds. And if that happened, then we have a much different situation where there is a genuine question, in my view, about whether or not the financial institution could be held liable for that unauthorized transfer. Because on the one hand, it was, in fact, the controller who forwarded the instructions to the bank. But if the bank doesn't have some procedure in place with the customer that's part of the agreement, then there's at least an argument that could lead to substantial litigation expense that because the controller was tricked into sending that email, that in fact the financial institution should be held liable for an unauthorized wire transfer. So, to understand what the banks can do to insulate themselves from potential claims like the potential claim in PSG, we have to understand the legal framework. And the legal framework, as I said earlier, is provided by the Uniform Commercial Code. And under the UCC, we start with a default presumption that if a financial institution initiates an EFT without authority of the consumer or of the deposit account holder, then the bank's going to be liable for that. So in other words, if somebody in your loan department receives an email from somebody they believe to be the customer or deposit account holder requesting that funds be wired out of an account, and the loan officer goes ahead and follows that instruction received via email, the presumption is that your institution is going to be held liable for that transfer if we later find out that it was not in fact an authorized transfer because either fraudsters hacked into the deposit account holder's email account and sent a phony email, or fraudsters didn't even bother hacking into the deposit account holder's account and instead were able to just manufacture an email that appeared to come from the loan officer. Now, banks have the ability to shift liability for unauthorized transfers if you and your deposit account holders have agreed to use a commercially reasonable security procedure to verify the authenticity of any payment order that comes into your bank. And so in my hypothetical example from a moment ago, if you have a loan officer who receives an email from a customer requesting an EFT, and that loan officer says, hold up, I can't respond to this email and just do as you are asking, I need to route this through our security procedure, which means I need to call you back, customer, at a phone number that I have on a note card kept at the bank, and have you verify not only the amount of the transfer, but also the destination and beneficiary bank account number and routing number to make sure that this is in fact an authentic transfer. If the bank does that and then the wire still goes out, then the bank has given itself a great deal of protection if for some reason the customer is able to come back and claim that it wasn't an authorized transfer. The keys for a financial institution to shift liability here are first and foremost to have an agreement with the account holder. I cannot emphasize that enough. The UCC does not provide the bank with any protection if all the bank does is say, well, we're going to do some things to keep your account secure. You don't worry about it. We're going to take care of that on our own. You have to incorporate the terms of the security procedure into your agreement. So what you're essentially doing is saying to you and the customer agreeing, this is the process that will be used to verify an EFT before it goes out. Then, after you have that agreement has to include a commercially reasonable security procedure. We'll talk about a case here in a little bit that holds that a bank simply responding to an email request from a customer to wire funds out is not commercially reasonable. So if that's the process that an institution relies upon to initiate electronic funds transfers, that is not going to be a commercially reasonable security procedure. And then, of course, the bank has to accept the payment order in good faith and not be the source of a breach itself, which we won't spend much time talking about because they're self-evident. If you know that a customer has been compromised, you shouldn't be sending out EFTs on their behalf. And of course, if the bank gets hacked, then you're the one responsible for the loss. So I don't want to take up too much of your afternoon here talking about commercially reasonable security procedures, but I do think it's helpful to understand some of the things that go into developing a commercially reasonable security procedure. Now, keep in mind, you're only going to be doing this for your larger non-consumer account holders. And so those would be people like businesses, again, schools, and other organizations that are doing EFTs on a regular basis. Some of the factors that you as an institution need to take into account are the customer size, the type of customer, the frequency of payment orders that they may be sending, So, for example, if you have a customer whose only EFT activity is sending payroll every 2 weeks, then that security procedure can probably be a lot different than a customer that is making vendor payments routinely and sporadically by using ACH or wire transfers. The second customer is a much bigger risk because it's much harder to establish a baseline of activity for that individual or that entity. And without a baseline, it can be hard to say whether one transaction or another may be unauthorized. The entity that's only doing payroll every 2 weeks is pretty easy because anything that isn't that biweekly payroll is probably an unauthorized transfer. So the cases I'll talk about commercially reasonable, meaning something to the effect of multi-factor. In other words, you've got more than one way to verify that the request is coming from your customer. So if you are going to allow customers to make requests via email, then in addition to receiving the email request and making sure it comes from the real email address of the account holder, you also need to do something like call that customer back. And so you've got multiple ways of verifying the identity of the individual. Single security measures are not going to be enough. In one case, a financial institution saw one of its account holders lose $1.9 million after an employee at the organization received a phishing email and provided the fraudsters with all the information the fraudsters needed to initiate transfers through the online system. The bank, however, had used a secure token technology as part of its security process, which required the customer to input a security code before it was able to authorize any kind of wire transfer. The court found that in this circumstance, the bank had used a commercially reasonable security procedure, and so the $1.9 million that was lost was not held to be the bank's responsibility, because even though fraudsters were able to break through and compromise the various security measures that the bank had implemented, that ultimately those measures were reasonable under the circumstances for that particular kind of customer, and so the bank was not held responsible for that, which was a good outcome for the institution. One of the things to be attuned to is the fact that you as an institution have to include in your agreement with customers a commercially reasonable security procedure. However, your customers do not have to accept that commercially reasonable security procedure. So in some cases, a deposit account holder may tell you, well, I don't really want to use, for example, dual authentication. I don't want to have two people have to sign off on every EFT before we send it because that's inconvenient for my business, or I don't have enough staff to justify that, or it's going to be the same person that does both anyway, so why even bother having that second authentication? Choice escrow is a case that demonstrates that it is possible for your deposit account holders who have been offered a commercially reasonable security procedure to decline to use that security procedure. And in the event that there's a compromise, the bank can still successfully shift liability to that customer. In choice escrow, there was a dual control identification that was offered to the customer that was essentially requiring two people to log in to verify transfers before they would go out. Court ruled that that was in fact a commercially reasonable security procedure and that the company had waived that security procedure. And so when they experienced a $400,000 loss at that real estate escrow company, it was not the bank's responsibility because it had offered a security procedure to the customer and the customer declined it. So one of the things I hear frequently is that there's concern at financial institutions about imposing too strict of requirements on deposit account holders, that the deposit account holder, if it's a large customer, may chafe under the requirements of a rule and may not want to use it, may not want to use the procedure. And under that circumstance, if the bank has done what it needs to do to offer that procedure and explain to the customer why they're offering that procedure, then they can allow the customer to waive it. It still creates risk for the institution because in the event of a loss, that customer is still probably going to look to the bank for reimbursement, but at least gives you a measure of legal liability protection. One of the things that was really helpful to the bank in this choice escrow case was that the cash management agreement actually included an indemnity provision that required the customer to reimburse the bank, even though the deposit account holder had sued the bank over reimbursement for the unauthorized wire transfer. Customers or financial institutions should think very hard about including language like the language up on this slide, because this language can potentially shield the bank from the burden and expense of having to pay for litigation that results from a customer who disagrees with whether or not liability should have been shifted to them. One other case that I'll touch on briefly here highlights the requirement that the institution actually have an agreement with the customer to use a security procedure to verify the authenticity of payment orders that come into the institution. In Chavez, a bank sent out $350,000 or $380,000 in response to a request for an EFT, and it was later disputed whether or not that was an authorized request. Well, the bank's defense was that its agreement gave it the option to use additional security procedures. And as a result, the bank had a commercially reasonable process because it could use some other procedures. The court rejected that and said, no, the UCC requires that you and the customer agree on a set procedure. And the fact that the bank can do additional things doesn't mean that that's part of the agreement. So what I generally advise institutions to do is to make sure that their security procedure is part of the agreement, but then also include language in the cash management agreement that allows the bank to unilaterally amend it. And if the customer doesn't do anything, then that amended agreement is deemed to be binding on the customer as though they had come in and signed it at the bank. This gives you the ability to incorporate the security procedure into your agreement, but also retains the ability of your institution to modify it from time to time, because as time passes, what was commercially reasonable 3 years ago will not be commercially reasonable today. And so you want to be able to maintain the ability to update that agreement and procedure without necessarily having to go out to every deposit account holder on an annual basis and renegotiate the terms of the agreement. I'll spend just a moment here talking about security procedures that are not commercially reasonable. But the key thing with these is one size cannot fit all when it comes to a security procedure. And that's really the corollary of the point that I was making earlier, and that is that a commercially reasonable security procedure requires multi-factor authentication, more than one way of verifying the authenticity of a payment order. In the case I'm talking about now involving PATCO, the bank actually had a fairly robust security procedure in place, including a lot of back-end features like risk profiling that occurred without the customer or depositor having to have any involvement whatsoever. However, one of the things that the bank did that turned out to be a real problem was the software had included a dollar threshold where any transaction over a particular dollar amount would trigger additional scrutiny by the bank. Well, the bank thought that was a swell idea, and so they set the threshold for every account at $1. And so as a practical matter, every single transfer required that secondary authentication, which meant that the users or depositors were entering their username and password to initiate, and then they were having to initiate the transaction, and then they were having to enter the second set of usernames and passwords that are only required for a transaction over a certain dollar threshold. And what that allowed the fraudsters to do was to use their key logging software to get all of the usernames and passwords. And so really the institution would have been better off setting that dollar threshold at different levels depending upon the customer who was engaging in transactions. This particular depositor had a fairly routine history of transactions, and so setting that dollar threshold at something like $50,000, given that their largest transaction was $36,000, probably would have provided an effective defense against this particular transfer. So the problem here was that the bank attempted to impose a one-size-fits-all security procedure. I want to spend a moment talking about INSOFTVISION, LLC. This case is one I alluded to earlier. This case involved a bank that had the only security procedure was the receiving an email from a customer's email address. And what the bank argued was, well, we didn't have any steps at our institution that required the customer to enter a username or password or anything like that. However, in order for a customer to be able to send an email to us with a wire transfer, they would have to have the username and password for their email account. And so, in effect, our security procedure was to have a username and password for an email account, and from that email account, they could then send us an email requesting a wire transfer. The court rejected that argument. It said that the bank cannot outsource that requirement to some other service provider. Now, that's different from a situation that I think a lot of institutions have where they rely upon an organization like Fiserv to provide them with the tools that they need in order to process EFTs. In those circumstances, you have a contractual relationship with an entity like Fiserv who is providing you with services, and then you are then turning around and offering those services to your deposit account holders. So what this does mean, though, is that loan officer sitting in your loan department who's getting emails from deposit account holders saying, hey, send this EFT, send that EFT, is a large source of risk for your institution, because those emails by themselves are not sufficient to shift liability for an unauthorized transfer. And anymore, it's absolutely nonsense to think that the email address gives any protection, because fraudsters can quite easily replicate almost anyone's email address and make it appear that they're sending an email on behalf of somebody without actually having access to that individual's email account. So as you consider your cash management agreements, it's important to review them and then ask yourself, is the process that we have in place for verifying EFTs before they go out, is it commercially reasonable based upon some of the things that I talked about here today? And then do those agreements actually state the security procedure? And then one other thing I don't have on the slide here is, do your agreements provide you with indemnity and the ability to unilaterally amend as your security develops and you enhance your services you offer at your institution? So with that, thank you. If you have questions about that, feel free to email me, and I'm going to turn things over to Jesse.
Good afternoon. Thank you for joining us today. I am Jessie Johnston. I work here at the Dickinson Law's banking section, and my focus generally is on regulatory issues facing banks, and that's what I'm going to be speaking with you about for a little bit of time this afternoon. Specifically focused today on the things that are affecting your commercial customers utilizing your cash management plans. Obviously, we're going to talk about Reg CC today and the changes coming to be effective in July of 2018, and some implications here for Reg J. We're going to briefly discuss what's on the front here, and of course the issues of technology that the law just sometimes can't always keep up with. We're going to briefly discuss some of the new NACHA rules that are being implemented this year as well, and discuss a little bit about what you should be considering in your origination agreements that you might have with your commercial customers, as well as making sure that you are considering the various roles or participants in these NACHA agreements that you might have existing with these types of commercial customers. And then finally, as a bonus, I know you didn't come today to talk about the beneficial ownership rule necessarily, but Since it is now up and running, we've fielded a few questions, so I thought I would just highlight a few portions of the frequently asked questions that was published last month that may address some questions you have received already as this rule has been implemented, or perhaps we will be staving them off at the pass for you. So Reg CC, in May of last year, the Reg CC was updated, published in the Federal Register, and these changes have been discussed for the past year, but as I mentioned just a minute ago, they will be going live in July. The nice thing, I guess, the beneficial thing about the Reg CC changes is it doesn't necessarily require any immediate changes to your operations related to remote deposit capture and Reg CC issues. But as we're going to discuss here, Reg CC will be affecting the types of provisions that you'll want to see and include in your remote deposit capture agreements, or I'll refer to those as RDCs for the duration of this talk today. What you'll want to include in your RDC agreements with your commercial clients in these cash management type of situations. If you haven't gone back to look at what is in those RDC agreements, you may want to be doing that here in the near future, both to update the agreement that you are using going forward, given these changes to Reg CC, and as well as considering how you might want to push out these amendments to contract amendments to current cash management customers, given that these changes do affect the way that you may be doing business with existing customers going forward. Obviously, this is a discussion related to cash management and commercial clients. However, I think that there may be some points of discussion here that you will be able to discern and distill as beneficial provisions in consumer RDC agreements to the extent that that's a product you push out to your consumer clients as well. I know that I rely on my camera phone for depositing checks myself, so I know it's ubiquitous in our smaller community bank market here. The Reg CC updates are welcome and necessary, and although no bank likes to be told that they're going to be on the hook in certain circumstances, the changes to Reg CC are helpful because they're going to provide some clarity and consistency and predictability to issues that have been occurring with remote deposit capture checks. Namely, there have been problems with twice depositing of checks, once through RDC or perhaps twice through remote deposit capture and then once in the institution. So we've seen a few instances where a check is not properly disposed of or did not properly become endorsed and was once deposited through the RDC system, and then somebody will go into a financial institution, negotiate that check across the counter, and in that circumstance, prior to these changes in July, there was a little unpredictability as to which financial institution would be on the hook for the customer's losses. But this change to Reg CC clarifies that, which we'll discuss in a minute. It is necessary because, as I'm sure all of you are aware, a lot of commercial clients are heavily utilizing the RDC systems to keep their business moving, to the extent that they receive checks from accounts receivable or their customers. They need to pass those through into their accounts to be making payments. So this is something that many smaller businesses are utilizing heavily at your institutions. And there is also a lot of fraud associated with this. A recent study by the Association of Financial Professionals has found that there has been an increase actually in the amount of fraud experienced by organizations using RDC, up 4% in 2016 from 2015, which is reversing a trend that we've seen lately, which is a decrease in fraud related to check writing and issues. So while remote deposit capture offers a great product for our customers, it's also presenting a small risk with what do we do with these checks. Also, we're going to discuss a little bit today, concerns with the speed at which your commercial customers are expecting those things to happen now too. So not only are our customers expecting financial institutions to provide them with the ability to do a lot of their banking remotely, they're also expecting these functions to have same-day availability and be up and running pretty quickly. The preamble to the final rule related to Reg CC, you see it in front of you there. The preamble kind of gives us insight into what the main thrust of this rule is and can help kind of understand the somewhat esoteric language associated with the regulation. Effectively, this rule eliminates the second depository institution from incurring the loss, where they have taken a deposit without notice of a check that has already once been deposited. So the Federal Reserve Board, in drafting this rule, believed that the indemnity should be upon that bank, that the first bank, if they take that check from remote deposit capture, because they are in the best position to control what happens to that negotiable instrument and to require the restrictive endorsements. So given that your institution has privity of contract with these commercial customers who are utilizing RDC, your institution is in the best position to require certain provisions be met to protect the second deposit institution, an institution that may take that check over the counter with no reasonable way to know that that check has already once been deposited. So your bank, under the new reg, must indemnify a depository bank that accepts the paper check, the original check, or even an RDC, if it's a second deposit on that RDC, where you are the depository bank, the first depository bank, and you meet these 5 requirements under Reg CC. So if you're accepting remote deposit capture and you are the bank that truncates or essentially turns that image into a substitute check pursuant to that reg, you do not receive the original check, and you receive settlement for that remote deposit capture, then your institution may have to indemnify an institution that later accepts that check for deposit. We have dealt with circumstances where we've seen checks over $5,000 before being deposited twice. So this is something that has happened. So putting procedures in place to prevent that check that you've already accepted through the remote deposit capture from being recirculated at another bank is crucial. So how do you limit your indemnification? The first way to do that is through restrictive endorsements. The FDIC 2009 guidance on this issue has stated that if you are using RDC, you should require your customers to put some sort of restrictive endorsement on the instrument being deposited through this technology. In my experience working with financial institutions, I know that the majority of agreements that I've seen certainly do contain the requirement that customers place a restrictive endorsement on the back that includes something to the effect of for mobile deposit or utilization of remote deposit capture, something to that effect, to let the institution know that this is being collected or being submitted through the RDC system. I also know from working with these institutions that it's not being enforced. It's not being verified nor being enforced. And that makes sense. It's certainly not reasonable for your institution to look at every endorsement on a check to make sure that it contains the RDC stamp or whatever restrictive endorsement that you require for your customers. It isn't reasonable. When I first heard this, it was a little mind-boggling to me as a lawyer. I'm a rule follower for the most part, so of course, all of the checks that I'm depositing through my RDC service, I am putting that restrictive endorsement on, but I was a little startled to find that very few depositors are doing that, even commercial depositors. So requiring them to have a restrictive endorsement is going to be one way to mitigate your indemnification and possibly shift your indemnification under Reg CC rules. Again, you're not going to be able to police every commercial client, but perhaps if you were to flag certain deposits over a threshold amount to ensure that they have restrictive covenants, perhaps asking the system to flag frequent users of the system to ensure that they are providing the restrictive endorsements that you need, but having some way to occasionally check in and ensure that these heavy users are putting those restrictive endorsements on could be a crucial way to save you money and costs in the long run. So likewise, you need to consider your endorsements, your agreements with these customers. In the agreements, not only should you be including provisions related to ensuring your customers using your cash management systems are placing those restrictive endorsements on the instruments, but you should also include provisions shifting liability to these customers for the requisite indemnification that may occur under Reg CC. They are commercial customers. You can shift liability to them by requiring they indemnify you. You could certainly even have a reserve account if necessary for certain customers, again, if they're frequent users or if they've had a history of any sort of problems with restrictive endorsements or check collection before. Also, something to consider in your agreements with your cash management customers is support for any hardware or software that may be necessary for any RDC systems. I think many of our customers that I've dealt with for cash management purposes have particular machines or actual hardware that are being installed in commercial customers' workplaces to facilitate RDC deposits. And so making sure that not only are you including any sort of requirements from that vendor from which you obtain the RDC hardware and software that may be necessary, but also considering some provisions, including connection to Wi-Fi, firewalls. Your institution should consider evaluating these customers' operational controls, possibly implementing dual controls where there may be changes made to the hardware or software, and ensuring that in that agreement you include a secure storage and disposal of the original checks. This is a pretty crucial issue. Ensuring that your commercial client agrees to keep the checks for the requisite amount of time, but then have a secure and safe way to dispose of those checks after they've kept them for the length of time required. And that disposal should be on their site. And then your bank will need to assess how the customer's employees are responsible for handling RDC, that they're well trained, and your institution may want to consider including certain provisions as to what training looks like, how frequent training should be in those agreements that you have for cash management. You should also retain the right to review the physical and logical security measures around the RDC system, and hope that you never need to do that, but make sure that you are reserving the right to do that with your commercial customers in the event that you need to. And finally, you should also consider a change of control process for commercial customers as well. How do the systems get updated? How are they operated? And those should be addressed within the cash management RDC agreement. Again, I've already mentioned audits, but regulators want to see that the financial institution has maintained the right to enter and audit premise and procedures. This is especially important, again, if you are giving hardware to your cash management customer, that you have the right to go on site and ensure that everything is being properly secured on site and that all necessary training is being addressed. Also, not necessarily related to the cash management remote deposit capture agreements, but your institution should consider as you negotiate third-party vendor agreements for RDC software, systems, and hardware. Perhaps you want to negotiate some terms for training with the vendors. That might be an easy point of leverage and something that you might reap rewards from by being able to provide that type of training to your customers from your vendor. So there are a few implications for REGJ here that have fallen out from these Reg CC changes. REGJ, I'm guessing, is not something that your institutions give much thought to, but this is kind of indicative of where things are headed. So if you think about the evolution of negotiable instruments in the past 10 years, 15 years, we've come a long way. When the Check 21 Act first authorized financial institutions to create a electronic image and start passing checks rather than by mail or physical checks through the Fed in order to process those things, that was pretty big. We have remote deposit capture now, and we have this notion of a substitute check. There is the remotely created items, which is also known as a demand draft, where the payee is not actually endorsing the items, but a financial institution can receive a request for payment on a electronically created image or a paper check that's not a check as we conceive of it. And we now also oftentimes when we talk RDC, some institutions utilize a substitute check, but some institutions are pushing these through as ACH entries now. So there's a lot of moving parts to this. What is left as a black hole right now, or kind of an unanswered question for a lot of institutions and a lot of banks that have heavy volume with the Federal Reserve banks, are what is happening with the digital check issue? So REGJ discusses how the Federal Reserve banks take, collect, return, settle these instruments. And not addressed right now are electronic checks. So companies currently are offering services that will allow commercial entities or even consumers, if they so choose, to create a check off of their desktop. I can utilize a software program, this web-facing program, to make a check. I draw my own check and I email that check. So there's never even a paper copy to begin with. It's not an image that's been truncated and submitted as we contemplated. It's the new frontier of the ECIs, and the Federal Reserve has proposed prohibitions on their acceptance of ECIs at this point. Reg CC leaves the legal status of ECIs unaddressed, although these electronically created items are defined in Reg CC. So we're not really sure what is going to happen, but there is a disconnect. There is a gap that exists right now between these products that are being pushed out and the way that they're being handled in the system. So it's not always as easy as we've described in Reg CC, where the bank that captures the remote deposit is obviously on notice that deposit is being captured remotely. However, that's not always so obvious to the first bank of deposit with electronically created items. There's nothing about that electronically created item necessarily that would tip an institution off that that's what it is. So we have to stay tuned here and see if perhaps the proposed Regulation J that's been issued by the Federal Reserve, currently open for comment, gets any traction, or whether this is addressed in a circular or whether it gets kicked down the road. So NACHA updates. This is Phase 3 we have entered. We'll briefly discuss that. We'll talk about third-party sender registration for those of you that are late to the game there, and I'm going to highlight a few issues with ACH agreements with your cash management clients. Phase 3 was implemented 2 months ago-ish now, so hopefully everyone is on board facilitating those same-day credits by 5 p.m. local time, and I have not heard many causes for concern. The phases have been gradual, and this is phase 3 of 3, so hopefully your customers are appreciating those deposits showing on the same day. One thing that the new NACHA rule for 2018 requires that originating deposit financial institutions, or ODFIs, are registering third-party senders. So that deadline has come and gone. I'm not sure. I've heard of some institutions that were even perhaps not aware that they needed to be doing that. But essentially, this requires you to put NACHA on notice of any third-party senders that you have agreements with. So in this context, we're talking about commercial customers that you may be using that are third-party senders defined by the fact that they are processing entries on behalf of an originator. So in these circumstances, you can identify your third-party senders because the bank, as the ODFI, does not have an agreement with the originators. So essentially, the ODFI is relying on the third-party senders to ensure compliance by originators. Originators being perhaps other smaller commercial clients, consumers in certain contexts. So NACHA is requesting that the ODFIs register their third-party senders. In order to do this, obviously, your institution will have to identify who their third-party senders are. And again, those are any customers that you have that are your direct customers, who have customers that are not your customers. For example, payroll systems often represent these types of institutions or these types of organizations. And so identifying and registering those is going to be crucial. There is a pretty handy tool that NACHA has provided to help your institution identify what type of NACHA participant you have. So if you're unsure whether you are dealing with a third-party sender, which you need to register, or a third-party service provider, you can go to the NACHA website to help you discern which type of a contractual arrangement you have engaged in. This is also probably a good time, given your necessity, to go back and ensure that you understand what type of participant you have, cleaning up those agreements with the various participants you may have. So I'm sure many of your institutions in the cash management capacity have originator agreements with various commercial clients to assist them in processing those various receipts and entries. But ensuring that you have the necessary provisions in those agreements is crucial. So NACHA requires that your origination agreements contain provisions that require the originator to abide by the NACHA rules, restrict certain abilities to create certain entries and otherwise. There are 5 provisions which are required, but the fallout from those 5 provisions is a little bit more encompassing. So while NACHA requires all originator agreements to include that the originator will abide by the NACHA rules, your institution may want to look at beefing that up a little bit. As I'm sure you're aware, NACHA rules are not accessible with a Google search. Ensuring that your originators understand how to obtain a copy, for example, and that they have to abide by that, what particular requirements that includes for their role, their participation role, are important as well. So finally, we're just going to briefly discuss here, as we are nearing the end of our hour, the beneficial ownership rules. I believe they went live on May 12th or May 11th this year. There was a handy, you can't see my air quotes there, handy frequently asked questions provided by our regulators. That was put out in April of 2018, a whole month ahead of the implementation date. So if you haven't put your hands on that FAQ, it is helpful if you're running into questions. Although the world of frequently asked questions is still pretty small, according to our regulators, compared to some of the questions we've already been asked here from various clients trying to make sure that they are getting the beneficial ownership right. A few things I would direct your attention to related to the beneficial ownership are conversations they have in the FAQ about complex entities. So certain entities, as I'm sure you're well aware, you drill down to ownership at the 25% threshold and find that you're looking at another legal entity, another LLC or partnership owning part of that. So as you continue to drill down, if ownership is in a private capacity where you can obtain a driver's license, you are instructed to do so, for example. However, there is a provision on question 18 that relates to investment vehicles, which has been something that's been raised a few times around here. So addressing those instances where you've drilled down and realized that 26% owner is actually some type of investment vehicle, what do you have to do? And there's also been some questions on what type of verification the financial institutions can rely on. Question 6 in the frequently asked questions addresses the fact that an institution is allowed to rely on the certification form. So we don't need any MacGyvers out there. If your commercial client makes representations to you, you are allowed to rely on those representations, which kind of gives you a little safe harbor or reprieve from certain circumstances. And then finally, the frequently addressed questions states that there is no retroactive application to the beneficial ownership rule, but I do not think they caveated that as well as they should have. If your institution has a account owner that is grandfathered into this beneficial ownership rule, but the bank has any reason or any notice that ownership has changed or that the control element has changed, your bank becomes obligated to engage in the requisite CIP and CDD here. So providing some employee training related to this, especially for those bankers working with the cash management programs, will be helpful here so that there aren't any situations where the bank did have notice of any sort of change in control or ownership, but because the employee wasn't aware that was an occasion which required retroactive application, missed the opportunity to get that. So if you have any questions about beneficial ownership, NACHA, Reg CC, there's my email address and my phone number. Please reach out and we can see if we can help you. Thank you for attending today on behalf of myself and John. We appreciate your time and we hope you found something helpful in the cash management webinar today.